So without further ado, we'd like to talk about the legislation. We'd like to talk about Section 248.1 of the Income Tax Act, and specifically 248.1c, which deals with experimental development. And of course, we've chosen to isolate or confine our discussion to 248.1c, primarily because most of the claims that are put forward are experimental development rather than basic research or applied research. Now, one of the issues that we have heard a lot about from taxpayers across Canada, as well as tax preparers, is there's a disparity in the viewpoint. And Justice Bowman, I'd like to ask for your opinion on this, but we're looking at 248.1 on the screen, and essentially what it's talking about is advancing technology for the purposes of creating new or improving existing materials, devices, products, and processes. But the key expression here that I would like to focus on and get your view on is what it really means by including incremental improvements there too. Could you comment on that, please?
I think the definition in 248.1 includes incremental improvements. Is there to fill a gap, or what is perceived as a gap in the legislation. In other words, CRA was, in all history, taking the position that it was just, there was something already invented, but they were improving on it. That was not experimental scientific development. I think in the definition I had used the word infinitesimal improvement.
Yes, you did.
And I think that what I meant was to comment on the incremental improvements there too. In other words, it didn't have to be a brand new product. It could just be an improved product.
Now, what's very interesting is oftentimes we see CRA denying claims because of the fact that they're taking a position that routine engineering was used, and oftentimes it's used in a way such as this, that known methods were used to resolve a problem. And the way that quantum tax law chooses to understand the legislation and also the case law that exists would perhaps not necessarily be in a restrictive matter, but would really like to have your opinion on this expression. This claim has been denied because known techniques were used to resolve the problem. Well, I would assert the following, that the term incremental not only means adding something small, but it also means adding something small to that which exists. Perhaps someone else's work, perhaps a body of knowledge on a specific area of science or technology. And to the extent that a taxpayer adds to a body of knowledge, which includes the use of arguably known practices or known techniques. My question to you, Chief Justice Bowman, would you say that the term incremental or incremental advancements there too, in this particular case, would you say that that would allow for an addition to a known technique?
Yes, definitely. I think the incremental implies to be an addition or a minor improvement even. I can't imagine what known techniques would be used by Thomas Edison when he invented the light bulb. And yet, one of the questions that was a way to experimental development.
Absolutely. Another thought is, if it's so that the use of known techniques to resolve an uncertainty are ineligible for SR&ED, one would argue that there may be no claims for microbiology in Canada if the use of a microscope, the use of a petri dish, or perhaps a technique of, say, adding a chromosome or altering a chromosome or adding a protein. Well, it might be that through observing an organism through the lens of a microscope, a scientist might come up with a cure for cancer, as an example. And if you use known techniques, such as, the method in which the tasks that he performed, the method in which he analyzed it, but yet he advanced knowledge, would it not be eligible for SR&ED based upon the advancement of knowledge?
Yes.
So I think there's a certain disparity between taxpayers who are gaining knowledge, advancing knowledge, quite legitimately, where there's incremental improvements. And CRA is all too often, and by the way, there are good people in CRA, and many of those as well. However, we do see a lot of situation in every jurisdiction across Canada where claims are being denied simply because of the fact that there's a failure to see the incremental portion. I would argue, and I would ask for your clarification on the following, Chief Justice Bowman, but if in fact you were not adding to a technique that exists or utilizing a known technique, then it wouldn't be incremental at all. I would argue that in the case that there was a forward advancement, one of groundbreaking nature, one that contained nothing but techniques that are unknown, well, that would not be an incremental improvement. I would argue that in order to be an incremental improvement, you'd have to be advancing or furthering techniques that are already known, techniques that are employed.
Are you asking me a question or are you making a statement?
I am doing both.
Well, tell me what you're doing, because I think that for there to be scientific research, it doesn't need to be necessarily using only routine methods. Say Thomas Edison never used very routine methods to invent the light bulb, but nevertheless invented the light bulb.
Chief Justice Bowman, one thing that you're known for, and that is your reasonableness, the accuracy in your decision, compassion in the decisions, and empathy. I think that the clarity that you give in your decisions go a long way. And what I'd like to do, without further ado, I'd like to move forward, and for some reason our slide isn't moving, Deljeet. Is it something we can do? Yeah. So I'd like to deal with this very question. And you mentioned a moment ago, you cited part of your reasons for your judgment on Northwest Hydraulics. Now, this discussion that you and I have just been having about whether or not known techniques could be used in order to advance technology, and whether that would preclude a taxpayer from making a claim, may well be addressed in this portion of your reasons for your judgment. Now, I have a very curious question for you. The initial part of your reason for this decision, you said, I shouldn't have thought it was necessary to say so. So I suppose I'm reading between the lines, and I've often been curious about this, but would that suggest, it seems to suggest surprise, that there's a need to say so. When you say I shouldn't have thought it necessary, so would you say that in the case of Northwest Hydraulics, that there may have been some of that, CRA may not have been accepting the infinitesimal increase? It might have been that they were trivializing, CRA was trivializing the advancements that were made?
I don't know whether I was doing that or not, because I don't think that the advancement in Northwest Hydraulics was necessarily trivial.
No.
They were significant advances. Mm-hmm. But
I mean, some of the issues in Northwest Hydraulics may, involve things such as, sedimentation, erosion of soil, there was turbidity. Arguably, it was an ancient science. I mean, they had dams in Egypt.
Yes. So
to the extent that the techniques that were used might have been new, and for certain were new, and of course, novelty isn't really the question. I would ask you that, was it more the resultant knowledge than the actual techniques that was performed that would have constituted an advancement in your opinion?
It might have. Indeed, I would say that we look at the result in determining whether there is a scientific research. Doesn't necessarily mean that everything has to be routine and methods used.
Fair enough. So I think this whole subject is highly complicated. There's many, many subtleties. And the fact that, through your decision, you have provided the clarity. There was an absence in the law as far as direction, which, for taxpayers and for CRA alike, to be able to adjudicate claims. And I think this term is interesting, the one you used. I'm not sure why you chose that term, infinitesimal. What was behind your thinking when you chose to use that term to describe it?
It's a big word, isn't it?
It is a big word.
But all I'm saying is that does not need to be a dramatic increase in knowledge or a dramatic result. could be quite a small result, but nonetheless it still involves scientific research.
Yeah. So in terms of the term infinitesimal, in mathematics it means a number that's more than 0 and less than 1. Correct me if I'm wrong. In the vernacular, it just means a very small amount. So really what we're talking about is defining the quantum of knowledge that's necessary to achieve or to acquire in order to be considered an advancement.
Well, that's what I said there.
It is.
Most scientific research involves gradual, indeed infinitesimal progress. Spectacular breakthroughs are rare and make up a very small part.
So how would you deal with a CRA auditor that fails to recognize this small infinitesimal progress and saying, well, look, this is nothing, groundbreaking, this is nothing profoundly different, it's essentially the same. Well, essentially the same, albeit true, doesn't necessarily allow for an infinitesimal progress. How would you deal with a CRA auditor, say a research technology advisor, who was not open to reason on this matter?
File an objection and appeal.
There you have it. That's why we're here. We'll move on again to the next slide, and somehow, here we are. Now, here I find that your reason for the decision was profoundly insightful, as is many other of your judgments. But here you say, if the resolution of the problem is reasonably predictable, using standard practice or routine engineering, there is no technological uncertainty in this context. Well, interestingly enough, the CRA effectively has cut and pasted your decisions on Northwest Hydraulics, and they've superimposed them into their own guidance documents. I'm sure you're aware of that. In most cases, it's a fairly accurate extraction, and other times they've added some things to that because it hasn't been accredited per se, but the content is largely from Northwest Hydraulics. Now, one of the points in the eligibility of work document 86.4R3 and some of the other guidance documents did talk about the same thing. This came from you. And what's interesting is when we see a decision coming down from CRA that says the work was not qualified because standard procedures were used to resolve the problem, what part of that, of your decision, do you think they might be ignoring?
Well, they did not give sufficient, in my view, sufficient effect to reasonably predictable. I think that if there's reasonable predictability, the fact that only routine engineering is utilized in reaching that conclusion, I do not think disqualifies the scientific research. That
is the heart of what we're talking about, and perhaps why there's such a disparity. For some reason, I think the camera's gone off position. I'll move a little closer to Chief Justice Bowman, if you don't mind, that is. So what we're really saying, or at least what Chief Justice Bowman is saying in his decision, it's not that work that's performed using routine procedures is ineligible for SR&ED at all. It's that where there's where the result or the problem is reasonably predictable using routine engineering. So it might be that bona fide SR&ED activity, legitimate work, is performed using known techniques, standard procedures, as it were, but the result was not reasonably predictable. The omission of the term reasonably predictable is an enormous reason, in our opinion, as to why we're seeing the misapplication of the law.
Yes, I know.
So one of the things that I would almost be inclined to ask you about if I was, thinking about it driving over here to meet with you, was, in reality, is it more the actual tasks performed, or is it not the resultant knowledge that constitutes an advancement?
It's the latter.
Chief Justice Bowman, I've got to say, I quoted you countless times. And the purest definition for SR&ED that I have seen is your rhetorical question where you asked, was there an advancement? That is to say, a general advancement in the general understanding. We're really talking about knowledge gained. And one can look at tasks performed by scientists and engineers, and it's not that difficult to arrive at a conclusion based on those things that it appear to be fairly obvious after the fact. However, the resultant knowledge is really what we're talking about, and the big question is, if a claim is being adjudicated either by the courts, and quantum tax law has had the experience of arguing against Crown Counsel, who makes similar comments. We've heard in the courts that they've said standard routines have been used, or known methods have been used to resolve the problem. Well, I would assert that if the problem has to be resolved, the problem might be resolved through the use of a standard procedure, but it might be unknown which procedure. In CRA guidance documents, oddly enough, and we realize it's not the law, to paraphrase, one of the expressions in eligibility work document states that if it is uncertain which path, which route, or which system architecture, and I'm paraphrasing, is best suited to meet the objectives, it's considered an uncertainty. Now, when you consider the term path and route, normally these things are thought to be well-traveled roadways. That's what a path or a route is. I would suggest that, when you consider techniques and known procedures, those could be substituted for their own guidance documents, where it's saying which technique is best suited, which path or route is best suited. And oftentimes these path or routes might be roadways that you've traveled many times yourself. But if it results in knowledge that's not generally accessible, we would suggest that that would be something that needs better consideration to determine whether or not the result was reasonably predictable or not. Mm-hmm. I wanted to get your feedback on that. Does that concept, do you believe that the entire question of eligibility not only is based upon developing techniques that didn't exist, but perhaps choosing from existing techniques? Could it be that there are 3 or 4 or more techniques that are known, but without experimenting with them and seeing how they affect each other, would you say that that would constitute a legitimate uncertainty?
Well, I should think so. Yeah, that's quite odd. You don't know the results that you're in. You may use routine engineering procedures, but you don't really know what results you're going to get. Mm-hmm.
Well, we'll go on to the next slide, because I think this is a very interesting conversation. And to hear this directly from Chief Justice Bowman is invaluable, because one of the things that I believe is happening is we're seeing what was behind the decision. I mean, we can read the case and we can read your reasons for the judgment. But having said that, how does it replace hearing it directly? So we're most grateful again. What I'd like to do is go to your reasons for your judgment here, where it says, another very astute observation, and you say, what may appear routine and obvious after the event may not have been before the work was undertaken.
Yes, that's what I said, and what I meant there, if it was obvious, is that it may not have been obvious after the, or at least before the scientific research was undertaken, but may not have been that obvious before the work was done.
Again, profound wisdom. This is, an expression that I've cited many times in the presence of CRA, where they say, well, look, this appears to be, and that's precisely your words, it appears to be obvious, it appears to be routine. Well, I think to some extent it's human nature, and I think to some extent it explains part of the disparity. So I think it would be, CRA would do well to encompass into their training this concept.
Well,
we'll move on to the next slide. Another comment you made in your reasons for the decision is that you define routine engineering, and you mentioned here that it appears to have been the subject that has caused more controversy. As you put it, it's divided experts more than any other. So why is that? Why do you believe that?
Well, routine engineering, standing by itself without benefit of a statutory definition, is pretty routine. It's pretty, there's nothing unusual about it. That's why people disagree over it. I think it's high time that we looked at the definition of routine engineering as including aiming at least a the result of it is not predictable.
Mm-hmm. Mm-hmm. Well, the odd thing is you rendered this decision as Chief Justice in 1998, is that right?
I think so.
Still persists today. So I would say that that expression is equally as true in 2017 as it was in 1998. Let's explore a little bit further. Chief Justice Bowman, you have provided tremendous clarity on this subject. You've went on, this is the second part of your explanation about routine engineering, and you've described it this way. Briefly, it describes techniques, procedures, and data that are generally accessible to a competent professional in his field.
Yeah.
Seems to me that the underlying meaning of your decision would have required a great deal of thought in coming up with that.
I don't remember whether I did any thinking or not, but I can assure you, yes, I did.
Yeah.
And remember that routine, I meant, was intended to include techniques, procedures, and data. In other words, methods and information.
Information.
Yeah.
All right. So again, I'm going to describe what's happening. I mean, as a tax practitioner, with the Sheldon Group, of course, we have many of these discussions in various jurisdictions in Canada. Through the Tax Court of Canada, we argue these matters quite routinely, and we're hearing this both in the court and we're hearing it from CRA, that routine engineering is being regarded as the actual techniques that were used. You resolve the problem using that technique. Now, what you just said was data is information. Data, by extension, you would say, is knowledge. So if we were to take the last term, data, and isolate it for a moment, would it be fair to say that part of, not all of, but part of routine engineering would be the knowledge that's generally accessible?
Oh, of course. That's what data means.
That's what data means. But that's ignored. So one of these issues that we're seeing that is regrettably happening in the courts where proper recognition isn't being given to eligible activity because of the fact that data is being ignored. One of the points that we have made is that the definition for routine engineering must be supported by what would be akin to the proverbial three-legged stool. You have techniques, procedures, and data. And without these three supporting legs, the stool would topple.
Yes, because the third leg is an integral part of the stool.
That being said, routine engineering ought to never be identified as techniques that are known or techniques that are generally accessible. It must be that not only can it meet tests 1 and 2, but test 3. In general terms, would you say that if a company performs experimental work that results in knowledge that's not generally available, that would be constituted as an advancement?
Yes, I think so.
That equation is incomplete in the vast majority of situations where CRA is taking a position to deny a claim because of the fact that they're simply clinging to techniques and procedures. I'm not saying 100% of the time, but if they're not taking the time to consider whether or not the specific knowledge that's been gained by a taxpayer was generally accessible, and they're only looking at techniques and procedures, I would suggest that there is some misinterpretation of your decision. How do you feel about your decision being misinterpreted by the CRA?
Over 17 years of being a judge, I am not surprised at seeing my decisions sometimes being misinterpreted.
Chief Justice Bowman, I would like to take this just a little bit further. Okay, we're talking about an advancement as being an advancement in knowledge. And I think you said it perfectly here, that it really is to say it's an advancement in the general understanding. Now, having said that, you did pre-qualify this decision by defining it as routine engineering as being data techniques, procedures, and data that are not generally accessible. So it's understood that when you're saying, did the process result in a technological advance, that is to say, an advancement in general understanding, of course, the meaning would be knowledge that was not generally available. I think that's very clear. And again, that's a decision that I think is a definition that I think is the most clear of all. But I think you've done another service for taxpayers and for CRA in general, and for all of the courts. By the way, this decision has been cited in every case that's ever been heard by the Tax Court of Canada. It also has been cited several times by the Federal Court of Appeal. This is good law. You've essentially created and shaped the law that everyone depends on. And I think a lot of credit, obviously, goes to you. But what you've done here is, in this part of your decision, is you've taken it further. You've already stated that routine engineering involves knowledge that's not generally available. Now, you've gone further. You've, in effect, defined what generally available means. You say a technological advance in Canada does not cease to be one merely because there's a theoretical possibility that a researcher in, say, China may have had the same advance, but his work is not generally known.
That's true.
So I think that in order to, just to step back for a minute, if you don't mind, in order to define an advancement, you have to know what the uncertainty is. If an advancement means resolving a technological uncertainty, in an income tax law, it's generally held that an advancement in technology is inextricably linked to the resolution of a technological uncertainty. Would that be true? Would it also be true, then, that in order to determine to what extent there's been, or if there has been an advancement, what is routine engineering? You'd have to be able to demonstrate. Like anyone can say, we advanced technology by exceeding routine engineering. But if you don't define what routine engineering is, it's not very strong, is it? So here I think you've done that for us. You've made this very usable. You've made the SR&ED program accessible, and you've made it very user-friendly. Because what you've done here is you've defined what generally accessible is. So why did you decide to express it the way you have? I mean, obviously you had a choice. And to how much latitude do you afford taxpayers who are making a claim for advancing knowledge? And you could have said it very differently. You could have said, well, if the knowledge exists, then it's generally accessible. But you didn't say that.
No, I didn't. I wouldn't have thought it.
Why?
Why? Because I don't believe that it happens to be known to a few people on the Caribbean island. That in itself is not generally known.
Interesting way of putting it. There's a fairness there. There's a fairness there. And I think that if in fact, in the wisdom of the legislature, it was their intent to promote scientific research in Canada, then I believe that one should try to look at things in a fair way. And I don't know that this is necessarily the way that it's being considered. Like, we understand that the burden of proof is on the taxpayer to be able to demonstrate they gain knowledge. That's clear. But what we're not seeing is evidence that's being produced by the minister in many situations to say, well, here's an example of where this knowledge comes from. It's routine engineering because it's my opinion. Would you think that that CRA would do well to increase the training on reviewers with respect to the case law?
I suppose they would. I don't know. Any cases that I've heard involved scientific research, the witnesses that they call as experts on behalf of the Crown are well qualified.
Well qualified, and they're well spoken.
Oh yeah.
In fact, I would suggest that would be one of the problems that many of the cases have when CRA calls an expert witness or, say, a material witness. These are individuals who are accustomed to stating reasons why claims are denied. When the appellant calls its witness, they may have never done so before.